The hearing starts by quietly narrowing the battlefield before any real legal decision is made. One person is removed because he has no legal standing, immediately showing that family court focuses on recognized parental rights, not emotional connections or personal involvement.
White noise machine that we listen to all day. Anyway, all right. Well, Deputy Ames, would you swear in Ms. Carver for us, please?
You remain seated, but raise your right hand, please. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
All right, Ms. Carver, I have some preliminary questions for you. Bear with me. Have you received a copy of the petition? Yes. Okay. And do you believe, are you a member of any Native American tribe or band, or do you believe that you would be eligible for membership or have any reason to believe that your child or any of your children could be eligible for membership in any Native American tribe or band?
No.
Okay. Are there any other matters? I see we have a DS and a DP case here, both 2023 cases. Do those concern your children? Are those like support cases or something?
Yeah, I filed child support on both their fathers because they were not present, and I had tried to work out agreements throughout the years and it just never worked. And so I finally stepped up for me and my children, and then all this happened.
Well, it's okay. I just need to make sure that these are the only other cases that concern your children. Like, does any other court have any cases open?
I do
She
have.
has been arrested, Your Honor, so there is a felony charges downstairs.
All right, but that's just for you. That's not on the children.
No.
Okay.
It's child abuse, felony child abuse.
Yes.
Okay,
No
thank you.
No contact between the children.
Thank
All
you.
right. What I'm talking about is like guardianships, for example. Sometimes children will be in a guardianship with a relative already or something like that. So you just need to make sure we know about all the court cases that do involve your children. Okay, so you do have a right to trial on the allegations of the petition. You have a right to ask for placement today. You have a right to admit or deny anything in the petition. If you'd like to have a jury trial, you'll need to request that within 14 days in writing. My understanding, Mr. McFarland, is that your client would like to put in a no contest plea. Is that right?
That is correct, Your Honor. She was arrested on August 15th, 2 counts of child felony endangerment. It's my understanding, Your Honor. Because of that, she was standing here.
So if you enter a no contest plea, I'm essentially going to consider all of the allegations in the petition as accurate. Do you understand that? I'm sorry?
Yes.
Thank you. Okay. I think that's it for now. You have the right to have the petition read onto the record. I'm happy to do that unless you prefer to wait.
I don't need that, as we've gone over it. I believe that's the choice also. Is that correct?
Yeah.
That's it. Today. Ms. Heist, do you think it's in the child's or both children's best interest in this case for me to accept a no contest plea?
I do, yes.
Mr. Amadeo?
I do, Your Honor. If you want to put the work on the stand, I can, but I think we're covered on this issue. I can start to take a factual base if you like.
We'll get to that in a minute. I'm going to go through her rights with her first.
Absolutely.
All right. Okay. Ms. Carter, can you confirm you are the mother of both IC and RV? Is that right?
Yes.
If I accept your no contest plea, you are giving up your right to a trial by judge or a trial by jury. Your right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. Your right to have witnesses against you appear and testify under oath at trial. Your right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. You understand you'll be giving up or waiving the rights I just indicated to you if you enter a no contest plea?
Yes.
With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. It will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there is no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives, or in foster home, and order programs for you and your children. such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea? Did you get that, Ms.
She needs to get either closer to the microphone or speak up.
Yes.
And that one doesn't move, but maybe we could use our mobile. We need to get down there and get stuff.
Yes. Testing.
So do you understand the consequences of your plea? Thank you, much better. Any questions about any of your rights or any of the information I've given you so far?
No.
All right. Is anyone forcing you to enter a no contest plea?
No, ma'am.
Has anyone threatened you in order to get you to enter a no contest plea?
No, ma'am.
Are you under the influence of drugs, alcohol, or any other mental or physical condition that could impair your ability to understand what you're doing right now?
No, ma'am.
Has anyone promised you anything in order to get you to enter a no contest plea?
No, ma'am.
Would you say your decision to enter a no contest plea is one you're making of your own free will?
Yes, ma'am.
Very good.
The mother's
Alright.
decision to enter a no contest plea changes the direction of the entire case. Instead of debating whether the allegations happened, the courtroom immediately shifts toward determining how the children should be protected moving forward.
All right. Before we go into the basis for the plea, Mr. Amadeo, from my conversation here with Ms. Carver, it looks like there are 2 civil court cases that concern the children. Is there, are both of these children with their non-respondent parents at this time?
Yes, Your Honor, both are. In fact, Andrea Cartwright, who's the attorney for non-respondent father, was on earlier. I told her I didn't think you needed her, but she made an appearance that she's filing a custody order. So I believe things are moving in that direction.
And there are bond conditions, is that right, Mr.?
Yes, Your Honor, she's to have no contact with the 2 minor children.
All right. So what role will the department be playing in order to provide further protections for the children? Considering that there's bond conditions and that the children are already with their non-respondent parents.
That is.
Well, one of the fathers is actually putative. Isabel's father is putative. He had a DNA test hearing on the 28th of August, and he has not received the results back yet. And it happened in Washtenaw County Prosecutor's Office, because that's the county he lives in.
Right, so there's no actual order then as it relates to that child, is that what you're saying?
Correct.
That's correct.
Okay.
I did call that prosecutor's office when Marie met this yesterday, so I expect they'll get back to me in 30 days or so.
Curry is the father's name. He told me, they told him it takes about 4 weeks to get results back, and he told me he would send me the results when he gets it.
All right. So is the idea then to offer services to the mom based on the allegations? Is that what you believe your role will be? Because with her pending criminal cases, I'm not sure how much she's going to really engage in services.
I mean, yeah, I mean, the case, we plan to just transfer it over to foster care workers right here at us. So I'm sure, she probably has kind of an idea on what services we can, try to provide Jasmine, pending, her criminal.
The department is willing to serve its mom if she's willing to do.
I can't hear her at
Oh,
all.
I apologize.
Do you want to come up to the podium and give us your name? Thanks.
Eva Kopas, EVAKOPAS. The department is willing to serve its mom if she's willing to do the services. Despite the criminal hearing, goal is still reunification, and so we were willing to work with mom. I will also be supervising the children in the homes, visiting them, making sure that any services that they need will also be addressed as well. So we can plan to move forward as if this were a regular foster care case.
Have you spoken to the respective fathers?
I have not. Technically, this case is not assigned to me for 5 more days, but I wanted to be here to get a jump start. So my plan is to meet with them this week and discuss their plans for what they would like. I think that any of the services that we can offer mom will benefit her moving forward, even if she does not regain full custody of her children, that they will still benefit her and her parenting.
Mr. McFarland, does your client intend to engage in services?
She does, Your Honor. We've had that discussion.
Okay, all right, well, all right, we'll let the petition proceed forward then, as long as you think that's in the best interest of the children as well, Ms. Hikes.
Yes, I have not been able to see the children yet. We're still at prelim stage, but if there were any indications that these placements weren't appropriate, mom would be attending services and be ready if needed. I think so to progress with services is, I think, in the best interest of the children.
All right, all right. As it relates then to the factual basis of the plea, Mr. Andrea.
Thank you, Your Honor. Call Jamie Freeze to the stand.
All right, Mr. Reese, come on to our witness stand this morning. Thank you.
Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Good morning.
Morning.
Please spell your full name for the record.
Jamie Freese, Jamie Friess.
And Jamie, what's your role in this matter?
I'm the Child Protective Services investigator for the case.
Did you draft this petition?
I did.
Okay. As an investigator, and I guess it was fair to say, would you know more about this case at this juncture than anybody else?
Correct.
Okay. As the investigator of this matter, how'd you learn about the allegations contained in the petition?
We received a complaint in the beginning of July regarding physical abuse on both of the children.
In your opinion, do you believe there's substantial risk of harm to these children, their life or physical well-being if they remained in the care and custody of respondent mother today?
Correct.
Okay. Well, reasonable efforts were made to prevent removal of any?
There was safety planning that was involved within my investigation. And I did put a couple services in the home for Jasmine.
Okay. Who is proposed placement?
The testimony from the CPS investigator becomes the strongest factual support for court intervention because it is built around documented investigative work rather than emotional opinion. Instead of relying on accusations alone, the testimony connects medical findings, police involvement, physical evidence, and protective decisions into one consistent explanation.
What did you say?
Who is the proposed placement for the
Isabel would be with her putative dad, and then Reese with his legal father.
Okay. Do you believe proposed placements are the least restrictive to ensure child safety?
Yes.
All right. Did you hear or did you see Andrea Cartwright, the lawyer for one of the non-respondent fathers today?
I did.
Okay. Is it true that she said she was filing a custody order for her client?
Yes.
What's the actual allegation here, Jamie?
Physical abuse. There was injuries on Reese.
Okay. Was there a police investigation?
There was with Detective Putnam from the Adrian Police Department.
Do you know what the results were of that?
Yes, he actually did a search warrant at Jasmine's home, and he did find a belt that was located in the apartment. He sent his report over to the prosecutor's office, and then they authorized third-degree child abuse charges on Jasmine and Keyshawn.
Okay, so is it accurate that Ms. Carter has one count of child abuse third degree?
Correct.
And to your knowledge, is it true that Keyshawn Harrell's not living in the house?
My knowledge, correct.
And he is not the bio dad?
Correct.
Nor is he the legal dad, correct?
Correct.
Okay. So can you tell us about the safety plan you put in place?
In the beginning of my investigation, when I spoke with Jasmine, both children were actually not living with her. They were with other caregivers. And I asked Jasmine if the children could stay with those caregivers for the time being until I could fully, do my investigation, because it was the very first day I got the case. I didn't really know much about it. And she did not follow that safety plan, and she picked up the children that day. And so I put a safety plan in that Keyshawn is to not have any unsupervised contact with the children, and then not to use physical discipline on the children.
Based on your history in the field and on this case, do you believe there's statutory grounds for jurisdiction?
Yes.
What would they be?
The medical exam that was done on Reese, definitely, the results that came back on Reese, the safety planning that wasn't followed right in the beginning of my investigation. Jasmine still till this day cannot tell me where the bruises came from on Reese, so there is a huge, risk of harm for the children and the children's disclosures that were made during the interviews.
Would it be fair to say there's substantial risk of harm to the children at this point?
Yes.
All right, if Judge Saul were to authorize this petition and provide relief requested, what is your recommendation for parenting time, if any?
Well, due to the ongoing criminal, parenting time would need to be suspended until the bond conditions maybe get lifted.
Would it be fair to say that there would be no recommendation for parent time because of those criminal bond conditions?
Correct.
Is there anything else you want to add for Judge Saul?
No.
Your Honor, at this point, I ask that all supporting documents be admitted, and I have no further questions for this witness.
Objections?
No.
Very good, they are received. Any questions for this witness, Mr. McFarland?
I do. If my client's bond conditions were lifted to have supervised parenting time in the felony case, would that be something this agency would then go ahead with supervised parenting time?
Yeah, as long as the bond conditions are lifted.
Okay. If the putative father turns out not to be a biological father, my client would like to have her own biological father considered for placement. Can you get that information from her?
Yes.
Nothing further. Well, I guess. Yeah, nothing further.
It's, I see that has the DNA test pending, is that right? Correct. Okay, thank you. Just wanna correct.
Yep.
All right, any questions, Ms. Heiss?
Ms. Freese, what is the arrangement for sibling visits?
That's a good question. That would be a question probably for the foster care worker.
Okay, so as we leave CPS investigator and going into foster care, is it true that your recommendation is for supervised visits if and when the criminal no contact is lifted?
Correct.
Okay, and you have done it as a trauma screening checklist on the children, and you're willing to provide that to me as a baseline?
Yes.
Thank you, nothing further.
Thank you for your testimony. May I return your seat?
Thank you.
All right. Anyone else you'd like us to hear from?
No, thank you, Your Honor.
Good. All right, attorneys, are you satisfied with the advice, rights, and factual basis of the plea?
I am.
Thank you, Your Honor.
Yes.
Thank you very much. The court is also satisfied that the plea is knowingly, understandingly, and voluntarily made with a full understanding of the consequences, and that the record supports that one or more of the statutory grounds alleged in the petition are true. And of course, stems from the allegations of physical abuse in this case.
The judge spends very little time debating credibility because the legal requirements have already been satisfied through the plea and supporting evidence. The court formally accepts jurisdiction and explains why intervention is necessary under the governing statute.
Arisen to the point that they have triggered criminal charges against this particular parent. And so the allegations in this day, thank you. The court just received a copy of the written advice of rights. It's, our parent has acknowledged that she's received. I do find that jurisdiction is necessary and appropriate for purposes of offering the family services as a result of the home or environment being unfit as a result of that criminality and abuse. And the neglect that arises out of that to the mental well-being of the children as well as the physical well-being at this time. So the two provisions of the statute that the court's been asked to consider under MCL 712.2B, A, B, 1 and 2 are appropriate, and I am taking jurisdiction under those particular parts of the statute. Our next hearing will be the disposition hearing. That is where the case services plan will be reviewed by the court and determined to be well, and that will be what governs your road to reunification as far as this court's concerned. I can't do anything or affect anything as it relates to your criminal case that's being handled by a different judge. So in the event that your bond conditions change and parenting time may become available to you, that's something that we can talk about here. That's going to continue to be governed by our court, even in the event that your bond conditions get changed to allow you to see the children. Do you understand? So yes.
Yes.
Any other issues for today, Mr. Amadeo?
Just a couple, Your Honor, just whenever, I didn't hear a date yet, correct?
No, not yet. I'm looking right now.
They'll need an order today because there's a removal, and just a couple of housekeeping things. The two siblings, based on Ms. Place's question, are in different locations. Actually, a distance apart, Ipsy and Canton, you said?
Ipsy and Belleville.
Ipsy and Belleville, so we'll see what we can do about getting them some time together. And for what it's worth, I'll reverse Mr. McFarland. If Ms. Underwood wants to reach out to me, I will talk to the prosecutor about bond conditions. If Ms. Carter, hopefully she gets us down on misdemeanor or something, but if the bond condition is removed, I have no issue with supervised visitation if they're talking to my team, Judge.
I will address that with Ms. Underwood.
For purposes of disposition. All right, so between now and then, Ms. Carver, they'll be reaching out to you to sit down to talk about that case services plan, and it's important that you be part of that, to look at the services that they want you to do, to determine whether or not you can do them, where you're gonna do them at. I'm sure it's going to involve parenting classes, therapeutic interventions, a psychological evaluation. These are all things that are typical when we have an abuse case like this, to try to identify the things that got you into this situation and help you climb out of it in a way that will prevent that from happening in the future. Understand?
Yes.
Okay, very good. So we'll be back Tuesday, October 3rd for the disposition. Any further argument before we close the record?
Joe, thank you.
Can I make my finding?
I would just suggest that when we're done, the court gets my client's address and phone number, as she's currently homeless.
All right, we'll figure that out in a moment. Ms. Ice.
Nothing further, thank you.
Okay. All right, it does appear that there is a risk of harm associated with allowing these children to remain in the care and custody of their mother, so the court order will reflect also that the children have been placed with their non-respondent parents under the authority of our court, with the requirement that they do see each other at least monthly. Hopefully 2 to 3 times a month will end up being what happens, but we'll leave that to be arranged by our foster care caseworker, parents. We'll continue to monitor the situation. The order will reflect that ICWA does not apply, and there's no reason to inquire as to that, but if one of these other parents, one of the fathers, has that issue, I would expect that to be explored thoroughly and immediately. Come back for the disposition, and in the meantime, I'm not going to allow parenting time at this juncture, but if something changes with your bond conditions, just let us know, and we'll have a look at what kind of parenting time we can arrange for you. Any other questions?
I have one, Your Honor. I do see I am going on the 3rd to a conference.
Oh.
Maybe the 10th, we could do that date instead?
We have
Or
a
another
full day that day.
Okay.
I have some time on the 9th in the afternoon, 1:30.
That'd be fine, Your Honor.
Make that work, Judge. Thank you.
All right, so 1:30 on Monday, the 9th will be our disposition.
The final rulings reinforce that child safety outweighs every competing concern currently before the court. Placement with the non-respondent parents is confirmed while preserving sibling relationships through regular visitation requirements. The judge leaves room for future adjustments without weakening today's protective order. Parenting time is denied for now, yet the door remains open if criminal restrictions change and safety concerns can be reassessed. That approach reflects how family courts often operate under changing circumstances instead of permanent conclusions. The hearing closes with scheduling decisions, but the larger message is already established. This case will now be measured through consistent compliance, verified progress, and the ability to demonstrate lasting change rather than courtroom arguments or emotional appeals alone.